Recording.
Recording in progress.
Okay, I hope everybody was able to recharge and prepare for the afternoon's proceedings. Just looking at the proposed allotted time that people had provided to the court. I note the Caring Society, just before the break, we talked about possibly going further into their time for tomorrow, as Mr. Frater has concluded earlier. So we can see how far we get, but I think if the Caring Society is able to push through for 2 hours, I think probably be a good first day, and then we'll before we conclude for the day, we'll adjust the schedule for tomorrow, and we'll do that for each day, just to make sure we're giving enough time for everybody to make their submissions. So I believe it was is it Ms. Clark that is leading discussions on behalf of the Caring Society?
Good afternoon, Your Honor. Yes, this afternoon I will be speaking about the compensation decisions, and my colleague, Mr. Taylor, will be speaking about the First Nations child definition later on this week.
Okay. All right, Ms. Clark, the floor is yours, and you can let me know where you're at in your submissions as we are getting close to 4 p.m. and if you need a break in the middle of that. So I'll leave it to—
I probably will, Your Honor, just knowing myself and just being part of a team that we're not able to be all together, want to make sure that we give you as much information as you need to make your decision. So I will likely ask for a break at some point this afternoon, if that's okay.
Perfect. Okay. Without further delay, I'll turn it over to you for submissions on behalf of the Caring Society.
Thank you, Your Honor. So I'm very honored to join you this afternoon from the unceded Algonquin territory. And as I mentioned, I'm joined today by my co-counsel, David Taylor, and also present today in the courtroom are Anne Levesque and David Wilson. And together we are the legal team for the First Nations Child and Family Caring Society. Now, before I begin, the Caring Society wishes to acknowledge and honor the children who have been found buried on the grounds of various residential schools across the country over the last weeks, and as have been reported in the media and throughout the country. These children, those who have yet to be found, and the survivors of Indian residential schools and day schools and the 60s scoop are part of this case and have been part of the underpinnings and narrative that have supported the work of the parties as we've moved through this complaint. We are here today on their behalf and in their memories to fulfill the promises of the Truth and Reconciliation Commission's calls to action. This case is for the children, to fulfill our promises as Canadians to First Nations children across the country, and to ensure that First Nations children are no longer discriminated against by the Government of Canada. So today I will be addressing Canada's judicial review in relation to the tribunal's orders regarding compensation. My colleague, Mr. Taylor, as I mentioned, he will be addressing the First Nations child definition in the coming days. Today, we are asking this court to uphold the tribunal's orders in relation to compensation and dismiss the government's application for judicial review. The victims in this case, most of them children, were denied their rights under the Canadian Human Rights Act for an opportunity equal with other individuals to make for themselves the lives that they are able, free from discrimination, as the purpose of the Human Rights Act provides. Now, what's interesting, Your Honor, is there is no dispute in this case about the discrimination. Canada agrees that it discriminated against First Nations children, both in the provision of child and family services and in its failure to ensure access to basic social services under Jordan's principle. It also appears to acknowledge that its discriminatory conduct harmed First Nations children. They even went so far today to say that it is provable, just not proven in this case, that there was no individual evidence. Now, while we do not agree with the framing of the issue in this way, it is noteworthy that at any time during this case, before, during, and after the complaint, after the merits decision, or in advance of the compensation hearing, they could have called a single witness to come over this threshold that they have drawn in the sand, but they didn't. And so their statement today that they are open and want to compensate First Nations children is highly suspect, and we suggest should not be relied upon by this court. Discrimination is not a victimless crime. The victims in this case are not the Caring Society or the Assembly of First Nations or any of the interested parties or the Commission. The victims here are the First Nations children and youth who have suffered the consequences of Canada's discriminatory conduct, consequences that Canada recognizes are harmful. Parents and caregivers who are part of this case are also victims. While I will be focusing my submissions on the children, the Assembly of First Nations will be speaking about parents and caregiving grandparents. The Caring Society supports those submissions and asks that this court dismiss Canada's judicial review in its entirety, and in particular with respect to those parents and caregiving grandparents. Now, the Human Rights Tribunal made significant and specific findings regarding Canada's discriminatory conduct, findings that went unchallenged in 2016, 2017, and 2018. It is only now, given the direct financial liability imposed on Canada, that it seeks to challenge the tribunal's findings. Through this action, Canada is ultimately seeking to deny First Nations children their fundamental rights under the Canadian Human Rights Act. While Canada says that First Nations children are entitled to human rights remedies involving long-term reform and the long-term implementation of Jordan's principle, it is not prepared to respect and honor the right to compensation for First Nations children, a human rights remedy that acknowledges the infringement of dignity and what is lost by an individual who experiences discrimination. Now, what's more, the victims in this case, those who were removed from their homes, families, and communities, or denied a social service as a result of Canada's discriminatory conduct, will likely never benefit from long-term reform or the implementation of Jordan's principle after 2017. And because of that, our human rights framework recognizes the ability to pay individual compensation to those who have suffered harm, and not only protect the rights of future generations. This case is big. This case is complex, as Your Honor noted in the beginning remarks, but that does not mean that at the level of the child, it is not harmful and an individual experience. Now, before I get too far down the road, let me tell you what I hope to share with you this afternoon and likely into tomorrow morning. I'm going to focus on 6 principal areas. I tried to get it up to 7 like my friend, Mr. Frater, but I think I've got it down to 6. So here's what we're going to talk about this afternoon. First, I'm going to start by talking about the children impacted and harmed by Canada's discriminatory conduct. It's important to start here because this case has always been focused on them. From start to finish, both the Caring Society and the Assembly of First Nations, along with the Chiefs of Ontario, Anishinaabe Nation, and Amnesty International, have placed the children's needs, their lived experiences, and their best interests at the heart of this case and during our collective pursuit of justice. And through the examination of this harm, I will explain how the complaint arose, the roadblocks erected by Canada at almost every turn, and ultimately the evidence of harm experienced by First Nations children as a result of Canada's conduct. In the result, as found by the tribunal, Canada failed to protect the human rights of First Nations children across the country. Second, I'm going to address the tribunal's jurisdiction to award compensation in this case, both for pain and suffering and for willful and reckless discrimination. Simply put, there is no legal foundation or policy reason to deny the tribunal's jurisdiction to award compensation to the children in this case. Canada's arguments in this regard are not about advancing the rights of First Nations children or protecting the rights of victims. Instead, these arguments reflect a shameful strategy aimed at saving money at the expense of First Nations children and families across the country. Third, I'm going to take you through the compensation decision, or what we would consider to be the entitlement decision. This exercise will demonstrate to the court quickly and efficiently that the tribunal's reasoning with respect to both children who were removed and both who were denied services are inherently coherent, justified, and demonstrate a significant expertise of the tribunal and the particular expertise of this panel. As you know, this particular panel has been seized of this complaint since 2012. What's clear when you review the reasons, particularly when you read them in conjunction with the other decisions released in this case, they are grounded in the legal principles and foundations of human rights law. They are well-reasoned and entitled to deference. In applying the reasonable standard in this case, as the court is required to do, it will become clear that deference is owed to the tribunal here and its work should not be interfered with. Fourth, I'm going to directly address some of Canada's arguments. I'm going to talk about the class action law argument, this direct evidence argument or individual evidence, as Mr. Frater put it today, and the tort law argument. Some of these arguments are found in their factum and some of them were addressed more directly today. So I hope to bring those two together in my submissions. In our view, there is no legal basis to attack the tribunal's orders on any of these grounds. Human rights compensation is there to recognize and acknowledge the infringement of dignity, something that I did not hear Mr. Frater acknowledge once today during his submissions. And the direct harm that then flows from that infringement of dignity. And while I heard him recognize this harm in a general way, once again, Canada is attempting to provide legalistic, technical, and ultimately irrelevant context to a decision that impacts a child. When a child is denied a social service or a child welfare service only on the basis of their identity as a First Nations child, which Canada says it did, their dignity and sense of self-worth is damaged. Compensation under the Canadian Human Rights Act seeks to acknowledge that, and I hope to address that in full. Fifth, I will briefly discuss what we are calling the definitions decision regarding service gap, essential service, and unreasonable delay. When examined in the context of this case and the tribunal's previous findings of discrimination and non-compliance on the part of Canada, it will quickly become apparent that Canada's concerns regarding these decisions are baseless. Finally, number 6, the evidence in this case clearly demonstrates that Canada's conduct was willful and reckless. There is simply no way in which Canada's conduct could be understood or interpreted as anything other than willful and reckless. Devoid of caution is what the tribunal says. It knew at every turn, before, during, and after the complaint was brought, that First Nations children were the victims of discrimination. What's worse is that Canada was presented with solutions to fix the problems, evidence-based, well-researched solutions that came from experts across the country, clearly showing how this discrimination could have been redressed. There is no other reasonable finding in this case than to state that Canada's lack of action in this regard was completely devoid of caution in relation to the lives of First Nations children. So that is in a nutshell, roadmap, and I hope as we go together this afternoon, if questions come up, please ask. And as I said, I'm going to try to make sure that I've addressed Mr. Frater's comments as well as their factum, but please interrupt me at any time, because I think this discussion is so essential to understanding the nature of what the tribunal has actually done here. So we have to start our discussion with the children, the First Nations children who are the victims here. Something, again, that I did not hear Mr. Frater focus on, the actual lives of the children who have been impacted by Canada's discrimination. And in order to understand their experiences, we have to contextualize what this complaint is about and what has happened. This case is about two fundamental rights of First Nations children. One, the right to access and receive equitable and culturally relevant child and family services. Services that are aimed at supporting families so that children can remain safely at home. Two, the right to access and receive, without delay, equitable social services. Services that support and promote the child's right to equity and substantive equality. That's it. This is actually a simple case, and the compensation decision was actually the easiest part of what has been a long and complicated decision. While the funding formulas and the government bureaucracy, the contribution agreements and the operating budgets, all of these things can be complicated, the tribunal has already dealt with all of that, and they've done so in a very direct and articulate way. But for the children of this case, it has always been simple. Are they being denied fundamental human rights because of their race? Yes. And this is unchallenged by the government. This case has always been about the children who have been identified as the victims throughout this case, and Canada has always known that. So to provide a little bit of context for the complaint, it was brought in February of 2007 by the Caring Society and the Assembly of First Nations. As you know, Your Honor, the complaint alleged that Canada was discriminating against First Nations children and their families on the basis of race and national or ethnic origin, contrary to Section 5 of the Canadian Human Rights Act. The complaint alleged that the federal government's First Nations Child and Family Services Program discriminated against First Nations children and families. The complaint also alleged that Canada's approach to Jordan's Principle was discriminatory, as disputes between and among federal, provincial, and territorial governments caused First Nations children to be denied or adversely differentiated against when seeking services to achieve outcomes that are enabled by public services available to other Canadian children. And so I want to start with Jordan. Jordan was a real child with a real family who died in horrible circumstances exacerbated by the federal government's discriminatory inaction. And it's important that we keep Jordan in our mind and all the children who came before him and those who came after, who were denied the basic right to live free from discrimination. Jordan River Anderson of Norway House Cree Nation was born in 1999 with complex medical needs. He required long-term hospitalization after he was born, and ultimately his family turned to the Manitoba Child Welfare System in order to get him the medical treatment and services that he needed. After spending 2 years in hospital, Jordan was told by his medical team that he could leave the hospital and go into a specialized foster home to be out of the hospital and away from all of the noise and stress that is accompanied by being there. Once his medical condition stabilized, he was ready to go. However, for 2 years, Canada and the province of Manitoba argued over who should pay his medical bills. Ultimately, Jordan remained in hospital for the entirety of his life. He passed away at the age of 5, never having left the hospital. So in recognition of Jordan and at its core, Jordan's Principle ensures that First Nations children receive the public services they need when they need them, free from adverse differentiation or denials or delays. I want to make it clear here, though, it's not just about being denied or being delayed in receiving services. as suggested by my friend, Mr. Frater. It's about being discriminated against because of your First Nations identity. That is what happened to Jordan. If he had not been a First Nations child, he would have left the hospital when discharged by his doctors. And so on December 12th, 2007, the House of Commons unanimously passed a motion that the federal government should immediately adopt a child first principle based on Jordan's principle to resolve disputes for First Nations children. The motion passed unanimously. Despite the fact that it passed unanimously, and as noted by my friend, Mr. Frater, that it was not binding on the federal government, they chose not to implement Jordan's principle to the detriment of First Nations children across the country. Now, at the time the complaint was brought, there were no Jordan's principle cases. The federal government constructed a definition and a process for Jordan's principle that was so narrow that Canada repeatedly announced that no one applied. There was no functional and direct way to apply for services under Jordan's principle, and it was never publicized. And while I will be speaking about this later, this is one of the foundational reasons that the idea that a request for a service should be one of the terms and conditions of receiving compensation is nonsensical. Canada purposely and directly ensured that no one knew how to apply or even that they could apply for a service under Jordan's principle. In fact, Canada's response was to celebrate the fact that services were not being extended to children. In 2011, Canada's then INAC Deputy Minister awarded the Deputy Minister's Award to Canada's Jordan's Principle team for having no cases whatsoever. And that award, Your Honor, is found at tab 28 of our compendium. Also, at the time the complaint was brought, there was a significant overrepresentation of First Nations children in the child welfare system and a particular overrepresentation of kids in foster care. These children and families had very limited access to child and family services that other Canadian children and families had access to. There were almost no preventative services and virtually zero culturally relevant services. So what was happening is that child protection agencies were being forced to bring children into care in order to provide them with services. Now, while it's true that at the point of a removal can be complicated depending on what's happening in the family, as Mr. Frater said, that is true. But what the discrimination did here was never gave an opportunity to those children and to those families to access those services in order to mitigate what could be or could not be a complicated matrix of factors. They were simply never given that chance. And that is where the discrimination and the harm come together. Before this case started, children were suffering, and Canada knew it. They were waiting for their government to act. But now, after 14 years of litigation, they are still waiting. Canada recognizes the discrimination in this case, and it recognizes that children were harmed, but they are not open to compensating them under the Act. So the complaint was brought as a last resort by the Caring Society and the Assembly of First Nations after Canada chose not to implement the findings of two detailed reports. That is the Joint National Policy Review, which is at tab 2 of our compendium, and the Wande reports, in particular the 2005 report. And those are found at tabs 3, 4, and 5 of our compendium. Now, what the National Policy Review did was examine closely the situation for First Nation Child and Family Service agencies, as well as those receiving child welfare services from other entities. They found that these kids were receiving 22% less than all other Canadian children, and that's on page 19 of the compendium. That agencies could not provide services to children because there was no money. That's at page 22. They could not provide preventative services to try to mitigate risks within the home. That's at page 58 of the compendium. And finally, the National Policy Review suggested that the underfunding was so acute and directed only to First Nations children that there was potentially a Section 15 charter claim. And that's at page 101 of the compendium. So that was in 2000. And that policy review set out a number of recommendations that had been, if those had been followed at that time, this complaint likely would have never come to be. When nothing happened after NPR, the National Policy Review, Canada then engaged a team of experts to continue the work on understanding child and family services for First Nations children. Wande, the Light of Day, which is at tab 4, talked about Jordan's principle and the importance of it to ensuring the health and vitality of children. That's at page 155 of the compendium. And again, acknowledged that removals of children should be a last resort with respect to child welfare. In Wande, the journey continues at tab 5. At page 162 of the compendium, the team says that Jordan should be the last child to die as a result of denial of services. Sadly, as we know, particularly in Wapakika and Deer Lake, Jordan was not the last child to die because of Canada's inaction. The complaint was also brought in the context of the intergenerational trauma that continues to follow residential school and 60 Scoop survivors and their families. This context is important to understanding the magnitude of the harm in this case and the egregious nature of Canada's response to the tribunal's orders. Dr. Bombay's evidence in particular, which we cite at tabs 25 and 26 of the compendium, are important to understanding this context. Now, I know that the Assembly of First Nations will be speaking more about this issue, and the Caring Society adopts those submissions. Now, to understand the context for the complaint, and also why some of Mr. Frater's comments this morning are not going to jive up, we have to understand what happened. In 2007, the Commission elevated the complaint to the tribunal, but Canada sought judicial review of that. Ultimately, that judicial review was stayed and the process was able to begin. In 2009, Canada brought a motion to dismiss the complaint before the tribunal. That motion was ultimately argued in 2010, and the decision to dismiss the complaint was made in 2011. The Caring Society judicially reviewed that decision, and both the federal court and the Federal Court of Appeal ultimately allowed those applications for judicial review, and the complaint was returned to a differently constituted tribunal. Now, in July of 2012, the current panel that made the compensation decision was appointed. And so those panel members have been with us for a very, very long time. They have seen and heard all aspects of this case, as they note throughout their decisions. By February of 2013, things seemed to be, quote unquote, back on track, only to learn that Canada had withheld upwards of 90,000 documents. So the tribunal makes some important findings on this issue at tab 6 and tab 7 of our compendium, where the tribunal says basically that Canada knew it was withholding relevant documents, and the tribunal finds in 2019 that ultimately those documents were prejudicial to Canada's position and they ought to have been released. So that's an important context, which I'm going to come to in a little bit. But when Mr. Frater says, well, the statement of particulars that were prepared in 2009 don't specify willful and reckless. Well, part of the reason for that is that we didn't have access to the documents that demonstrated that because they failed to produce them. That's a very important point, and I will be coming back to it later. The other thing that happened before we get into the merits of the decision was that Dr. Blackstock was the victim of discrimination in the context of this case. So in 2009, she was ejected from a meeting on the basis ultimately of being a First Nations person and for being a part of this case, and the tribunal found that. And so the complaint was amended to include a claim for retaliation. And in 2015, the tribunal made an award of compensation to Dr. Blackstock for $20,000, $10,000 for pain and suffering, and $10,000 for willful and reckless. And again, I'll be coming back to this, but I want the court to have that number in the forefront of its mind. When Mr. Frater says that $40,000 is too much for a child who was removed or a child who was denied a basic social service, when you compare that to one moment in time for Dr. Blackstock, who is a professional adult, the comparison is hard to reconcile with Canada's argument. That in and of itself, I would say, demonstrates that the tribunal has been mindful of how much it is awarding. Now, in 2016, we received what we are calling the merits decision. And the tribunal made a number of significant findings regarding the discrimination experienced by First Nation children and their families. For example, at paragraph 344, the tribunal found that Canada's funding formula provides an incentive to remove children from their homes as a first resort rather than a last resort. At paragraph 384, the tribunal talks about the assumptions used to determine funding levels and how those ignore the real child welfare situations in many First Nation communities on reserve. At paragraph 388, they talk about how agencies, while being required to follow provincial and territorial legislation standards, did not allow them under the FNCFS program to deliver actual services based on needs to First Nations children and their families. They were also provided with insufficient funding to be able to control and improve the outcomes for children as they are statutorily required to do. And that's at paragraph 389. Now, one of the things that the tribunal says in its decision on the merits is that the formulas actually promoted negative outcomes for First Nations children and their families. That is an important finding. Now, while Mr. Frater can say, well, that doesn't say that children were actually harmed or that there was individual harm, we as adults who have a responsibility to care and protect children, we understand what that means. If you are promoting negative outcomes for children, that is not a good thing. Any child would be able to explain to you that if they are not given access to services because of their race, something bad will happen. And I think we should all be able to agree on that. Ultimately, the tribunal determined that Canada knew that its funding program was harming First Nations children. I will review these findings more in detail likely tomorrow, but it is clear based on the record that Canada knew that First Nations children were being discriminated against, and what's more, that they were experiencing harm. Now, with respect to Jordan's principle, the tribunal found that Canada's narrow interpretation defeats the purpose of Jordan's principle and results in service gaps, delays, and denials for First Nations children. And that is found at paragraph 382. So there have been significant findings in this case. And I would really urge you, to look at the decision on the merits, which I'm sure clearly you already have based on your questions today so far. But it does form the foundation for the compensation decision, and it's an important place to start. Now, after the merits decision came out, there was much expectation that the case was close to finishing. But as Your Honor knows, that is simply not the case. The parties and the interested parties have had to return before the tribunal time and time and time again in order to force the government to actually implement the principles and direction that have been provided by the tribunal in the merits decision. Just to quickly run through these, Your Honor, in 2016, there were two non-compliance motions brought, or two non-compliance orders, I should say, with respect to Jordan's principle. The first is CHRT 10, and the tribunal there said that all disputes and all First Nations children fall under the rubric of Jordan's principle. In CHRT 16, the tribunal said Jordan's principle applies to off reserve with respect to those services. In 2017, we had the Choose Life order, which I'm sure Nan will be speaking about later, but also the actual, I will call it the refinement of Jordan's principle. Refinement's not even the right word. It's actually having to spell out for Canada how to actually properly implement Jordan's principle. Now, Mr. Frater this morning said that Jordan's principle has been evolving since 2016, and that's completely inaccurate. Both the CHRT 14 and the CHRT 35 decisions on Jordan's principle were as a result of Canada's failure to implement the principles and guidance of the tribunal's merits decision. This was not the parties returning to the tribunal to think more about Jordan's principle or to expand Jordan's principle in ways that had not been anticipated. These were motions brought to force Canada to implement what the tribunal had ordered. And so to say that it should not be held financially liable because it didn't know what Jordan's principle really meant is simply an unfair recasting of what happened. Now, in 2018, we were forced to go back again with respect to the CFS programming, because again, immediate relief had not been achieved by the tribunal's decision, by the guidance of the tribunal. And as a result, children continued to suffer the acute, and I say this importantly because the long-term reform is really the only way that that discrimination will actually be eradicated for these children. But the acute nature of the harm had even not been addressed by 2018. And so the parties returned to the tribunal. Yes, I see you have a question.
Yes, I've got a question. You may cover it later on in your submissions related to just the jurisdiction, I guess. But in the merits decision, I want to get your thoughts on, in paragraph 483, and you just touched upon it in one of your comments. The last sentence talks about the panel requires further clarification from the parties on the actual relief sought, including how the requested immediate and long-term reforms can be implemented on a practical, meaningful, and effective basis. So from your perspective, the immediate and long-term, it's referred to in various parties, other submissions, but provide some context about the immediate and long-term reforms, please.
So the immediate, our understanding has always been, and the tribunal says in this decision and in other places as well, that long-term reform, so actually what really needs to happen with the CFS program is it needs to be thrown out the window, and something completely needs-based that respects and acknowledges the lived realities of First Nations children needs to be constructed. And I think the parties generally acknowledge that that cannot be done in 3 months, right? At the time that the decision was made, because there are bigger things that needed to be addressed. But there were some things that Canada could do immediately. For example, providing funding for a full host of prevention services and least disruptive measures to the agency so that they could actually provide those services, to actually provide funding for those things right away. In thinking about ways to do that. Making sure that social workers are paid on par with other social workers. This was something that could be done immediately. Making sure that there was adequate buildings and structures, and so that actual agencies and social workers could deliver just the basic programs that they're required to under the legislation. That could have been done immediately. But instead, by 2018, what we found was that very little had actually been structurally changed even within the existing program. And that was quite concerning. And so I think what the tribunal is saying here, and what has evolved over the years, is that it wants to partner with us collectively. And you see this in the approach that they've taken, where they keep coming to us and saying, come back to us with thoughts and ideas about how to fix things. They wanted to address the most immediate and acute issues of discrimination, like prevention, like least disruptive measures, and implementing Jordan's principle right away. So what paragraph is what paragraph 463 talks about, if I can just take you there for a moment.
I'm sorry, what paragraph were you referring to?
463 is that what Canada had been doing leading up to the decision was they had moved from Directive 20-1, which was the initial funding formula that paid 100 cents on the dollar for putting a child in foster care and almost $0 for really anything else. They moved into the enhanced prevention model, where they had tried to sort of adjust some things to make some things better. And what the tribunal says here, what Canada was really doing was adding support pillars to a house that has a weak foundation in an attempt to straighten and support the house. At some point, the foundation needs to be fixed, or ultimately the house will fall down. Similarly, a reform of the FNCFS program is needed in order to build a solid foundation for the program to address the real needs of First Nations children and families living on reserve. So what the tribunal really said was, listen, support those pillars in the immediacy of this decision that we've released, but you're going to have to take the whole thing down. And so there's a recognition made by the tribunal that this would have to come in stages. And you see in the merits decision, in fact, that they tell the parties, look, we know that people are asking for all different kinds of remedies. This is how we're structuring our remedial orders. We're going to have short, medium, and long-term reform, and we're going to have compensation. It was always understood that we would address these things at different times as the case unfolded. And so that's what the tribunal decided to do, because the issues, are complicated at the level of government. And I really want to emphasize that. They are complicated at the level of government. They are not complicated at the level of the child. And so that's why I think the tribunal wanted to address those acute things that are felt at the child level as soon as possible, like prevention, like least disruptive, like culturally relevant services, to try to get at the children as fast as possible. And then we can fix all the adult structures as we go with respect to long-term reform. And that's what the 2018 decision tried to get at. So when Mr. Frater says, well, we thought if we were paying it actuals, the discrimination would end. No, the 2018 decision is just one more pillar to support ultimately the foundation that should be brought down. It was just to be a piecemeal patchwork because Canada had really done very little to address the acute needs of kids by the time we got to 2018. So the discrimination was not over by that time. It really was just a way to give an extra support to the house of the CFS program before we ultimately and hopefully dismantle it and build something that's actually there for First Nations children's needs, recognizes their unique position within our society, the vulnerabilities that they experience because of being First Nation, because of being the target of racist and discriminatory policies in this country. We have to completely rebuild that. And that work, has to happen. But for the purposes of non-compliance, by 2018, we still hadn't quite got there. That was a long answer to your question, so I apologize, but that's the best I can do on that one.
Thank you.
So following that 2018 decision, there were then a number of other rulings with respect to the definition of First Nations child, and Mr. Taylor will be speaking about those later. And then in 2019, we have the compensation entitlement decision and the decisions that follow with respect to the definition of service gap, essential service, and unreasonable delay. And then, of course, the consent order, bringing the compensation framework into existence. So that's really an overview of the case, and important to understand the context, because this is not a situation where we were able to get to 2016 in any kind of direct or efficient manner. This has been extremely protracted, and Canada has fought the parties and the interested parties, and of course, ultimately the interests of First Nations children all the way along. And unfortunately, we see that again today. So I'm going to keep coming back to this notion of harm throughout my submissions, but I think it's really important to unpack what we're really talking about with respect to the compensation orders, because I'm worried that Canada misunderstands what the tribunal has done here. The ability to grow up at home, surrounded by your family, community, language, and culture is a basic right. We recognize this in our society and throughout our child welfare laws, that growing up at home is essential to giving children the best chance to thrive and live the lives that they're entitled to. This is why every piece of child welfare legislation in this country and the United Nations Convention on the Rights of the Child has, as part of its statutory scheme, an acknowledgement that children do best when they can safely grow up at home. This basic premise gives rise to the statutory obligation of state actors like child protection authorities to exhaust the least disruptive measures before removing a child and placing them in alternative care. In child welfare, the child is at the center of every action and decision taken by the state. The goal is to protect kids to the extent possible so that they can stay safely at home. Removal is the last resort, the last stop on the train. And provincial and territorial legislation requires that social workers examine their decisions through the lens of least disruptive and the best interest of the child. We know that separating children from their family causes harm. Canada knows this too. And this is where the harm and the discrimination come together. And frankly, this is why we see in Canada's own documents, which I'll take you to when we talk about willful and reckless, their own alarm and concern that First Nations children were and continue to be overrepresented in the child welfare system. For First Nations kids, the discriminatory underfunding of child and family services results in them being denied essential child and family services. While this underfunding has massive and complicated impacts on the entire system, which again, the tribunal did an excellent job of articulating, at the level of the child, which is who we're now talking about, Canada's discriminatory conduct meant that they were denied services that could have kept them safely at home. Instead, they were removed and they were never given that chance. This is where the discrimination and the harm intersect in this case. It's the infringement of the child's dignity, which is manifest by the harm of being removed. These children did not get the chance to access child and family services because of their First Nation status. That's it. It actually is that simple. But Canada is not wrong when it says that many First Nations children experienced further compounding and differing levels of harm following a removal. Although I think you would be hard-pressed to find a child who has been removed having a quiet 3 days at a friend's house. That's not the reality of how children are removed by child and family services. Now, some First Nations children removed, they will have multiple placements. They will have multiple challenges, forming attachments if they are outside of their family home for a long time. And certainly we know that some children were abused in their foster homes. Others still never returned home. These are harms caused by Canada's misconduct and failure to act. But these are not the harms that the tribunal is compensating for in this case. That is where Canada misunderstands what the tribunal was trying to do. While the tribunal in its decision gives a voice and an acknowledgement to these compounded harms and sufferings and wishes that it could do more, it recognizes the limits of its statutory authority and is not seeking to compensate for these compounded and differing harms. That's why they awarded the same amount to all removed children. The compensation ordered by the tribunal for these victims emanates from the discriminatory provision and the lack of services afforded to First Nations children because of their identity. I did not hear Mr. Frater once say today that these children did not receive what they needed because of their First Nation status. That is where the intersection of discrimination and harm come together. And so at the child's level, the direct harm they experience flows from Canada's discrimination. Now, the fact that Canada's conduct may also give rise to tortious liability does not oust their right to protection and remedies under the Canadian Human Rights Act. Whether a child was in care for 1 month, 1 year, or 10 years, every removed First Nations child experiences that same intersection of Canada's discrimination. They never had the benefit of adequately funded child and family services, and therefore they were denied the chance to stay safely in their homes because Canada refused to fund services that could have made that possible. And they failed to do this only on the basis of race. That is Canada's fundamental misunderstanding of what the tribunal has done in this case. A similar analogy has to be examined with respect to those who are receiving compensation under Jordan's principle. The harm flowing from the discrimination is clear and direct. Until 2017, Canada's discriminatory conduct resulted in First Nations children being directly denied social services because of their race or national and ethnic origin, or delayed in receiving social services so as to have a direct impact on their well-being. The services protected by Jordan's principle are essential to the best interest of the child. Canada recognizes this. This is embedded and ingrained and part of what Jordan's principle is all about, preserving and protecting the child's best interest and their well-being. And so the infringement of their dignity is stinging. Kids were being denied or delayed in receiving access to equitable social services. Essentially, the government was telling each child that they were not worthy of equitable services that support their well-being because they are First Nations. Again, this is where the intersection of the discrimination and the harm comes together. This harm, this direct infringement on dignity, is what the tribunal was compensating for. So I want to have that sort of be the setup here, Your Honor, because if Canada fundamentally misunderstands what it has done here, if it says we agree with discrimination and it says we harmed kids, if it fundamentally misunderstands actually this intersection, then this is yet another reason that Canada cannot be left to its own devices. When it says it wants to compensate kids, it acknowledges the harm, it acknowledges the discrimination. If that were really true, then they would not be seeking judicial review of this decision. Now, I want to move now, subject to any questions, to the jurisdiction of the tribunal in this case and its ability to award compensation.
Just one question. I know you mentioned that the other respondent, the AFN, is going to be discussing this, but again, you focus on the child. Just want to hear your thoughts about other people, the caregivers, so it's crystal clear what you submitted in terms of the child, but I just want to hear your thoughts on the other people.
So from the Caring Society's perspective, the family is a unit, and children who are the center of that unit, particularly for First Nations children, and that we find that in RCAP, we find that in the TRC report, and frankly, we find that really important principle in many of the reports that were submitted to the tribunal. The child is at the center of the family. And so it's essential that that family unit be protected as a cohesive group, as a cohesive unit. When you discriminate against a child, when you remove a child from the home, when you deny a service to a child, parents and caregiving grandparents also suffer. Certainly, and we talk about this in our factum, the Supreme Court has been crystal clear in the JG case about the impact on parents and those in caregiving roles when a child is removed from their home. Watching your child, as Marina Beadle had to do in the Pictou Landing case, watching your child potentially be removed from your care because of an inadequacy in access to social services impacts parents and caregiving grandparents. I mean, this is one of these issues, Your Honor, that's intuitive. And it becomes frustrating when Canada says, we recognize the harm, but you didn't drag anybody in here to say it out loud, even though we all know it. We all know that this kind of thing causes harm. With respect to the compounded harms and the proportionality and how much should people be getting outside of the human rights framework, that's not up for the tribunal's determination. The tribunal didn't really get to weigh in on whether or not victims should be going elsewhere. It has a statutory duty to do what it's required to do within the human rights framework. And so really, in answer to your question, the Caring Society supports AFN in its submissions on this point, and does view the disruption to the family, whether that be through the denial or delay in a social service, or in the actual removal of the child from a family, to cause harm that is compensable. Again, I come back to Dr. Blackstock's retaliation compensation decision, which was not judicially reviewed. She was ejected from one meeting. She's an adult. She got $20,000. A parent who lost a child to child removal, or a parent who had to watch their child suffer for being denied a social service, is getting 40. That's quite fair and quite reasonable within the scheme of the human rights context. And so we support AFN on that position.
Thank you.
So I will come now to the jurisdiction. And I think this is a very important place for us to focus, because in our view, what Canada is really trying to do is recast the standard of review and really entice the court to apply a correctness standard that is not fair and reasonable in the context of this case. But we will get there together. So the ability to award financial compensation under both Section 53 sub 2 and 53 sub 3 of the Act is an important tool in the tribunal's toolkit. The aim of making orders is not to punish the respondent, but to meaningfully vindicate any losses suffered by victims of discrimination and ultimately eliminate and prevent discrimination. The task of fashioning remedies is an intricate one, demanding innovation and flexibility on the part of the tribunal. And that's what the tribunal said in 2016 CHRT 10. These are statutory remedies that flow directly from a finding of discrimination. Canada argues throughout its submissions, and more pointedly today, that the tribunal does not have jurisdiction to order individual compensation in this case because it is a systemic case, that somehow calling this case systemic removes the individual impact from the child who has been discriminated against. In our view, Canada has provided almost no legal support for this proposition, but instead suggests that compensation is not available based on the fact that systemic remedies were being sought. The Caring Society submits that these justifications result in a finding that the tribunal does not have jurisdiction, and this cannot be reasonable in a case like this. So the court's task here is to determine whether the tribunal's decision is reasonable. And this includes determining whether the tribunal's interpretation of its home statute, the Canadian Human Rights Act, was reasonable. The place to start this discussion is by examining the guidance and the direction from the Supreme Court in Vavilov. So first and foremost, the Supreme Court has been clear that a reasonableness review finds its starting point in judicial restraint and respects the distinct role of administrative decision makers. That's at paragraph 75. A court applying the reasonableness standard does not ask what decision it would have made in place of that of the administrative decision maker, or attempt to ascertain the range of possible conclusions that would have been open to it, or conduct a de novo analysis. That is not what is to be done. Instead, to be reasonable, a decision must be based on reasoning that is both rational and logic. And if it fits within that context, there should be no de novo analysis, there should be no range of possibilities, and no one should be applying their own yardstick to a decision like this. Now, the reviewing court, that would be you, must be able to trace the decision maker's reasoning without encountering any fatal flaws in its overarching logic. And it must be satisfied that there is a line of analysis that could reasonably lead the tribunal from the evidence to the conclusion. That's at paragraph 102. We say, and I'm going to take you there, that that's exactly what the tribunal did here. Now, a reasonable decision is one that's based on internally coherent. And I want to pause here because Internally coherent is important. What I heard Mr. Frater do this morning was import his own views, or not his own, of course, but Canada's views about what's coherent and what's fair. But that's not actually the task. The task is looking at whether or not the decision is internally coherent within the context of the case. And when we get there, you're going to see that that's exactly what the tribunal did. Now, absent exceptional circumstances, a reviewing court will not interfere with the factual findings made by the tribunal. Again, we say Canada is coming very close to the line of asking this court to overturn certain factual findings. Now, with respect to jurisdiction and questions around a tribunal's interpreting its own statute and scope of authority, the Supreme Court is clear that the standard to be applied is reasonableness. The tribunal's interpretation of its statutory grant of authority is generally entitled to deference. That is your starting point. Did the tribunal look at its own framework? Did it consider it? And if it did, then generally that finding and that determination is entitled to deference. A reasonableness review involves determining whether the tribunal properly justified its interpretation and whether the tribunal has properly justified its interpretation in light of the surrounding context. And again, this is one of the reasons why I painstakingly took you through from start to finish this case. The context for this human rights complaint, the number of children impacted by Canada's discriminatory conduct, is very important to the overall interpretation of what's been done here. Now, whether an interpretation is justified will depend on the context, including the language chosen by the legislature, and the Supreme Court is clear that where a tribunal is given discretion, it would be unreasonable to fetter that discretion. Human rights compensation is discretionary. This will be the last thing I say about Vavilov before other times I talk about it later, but I think it's very important that we pause on paragraph 110 because as you'll see, the tribunal did not go outside its jurisdiction, and here's why. This is what the Supreme Court says at paragraph 110. If a legislature wishes to precisely circumscribe an administrative decision maker's power in some respect, it can do so by using precise and narrow language and delineating the power in detail, thereby tightly constraining the decision maker's ability to interpret the provision. Conversely, where the legislature chooses to use broad, open-ended, or highly qualitative language, for example, in the public interest, it clearly contemplates that the decision maker is to have greater flexibility in interpreting the meaning of such language. That is very important to the discussion of jurisdiction. The Canadian Human Rights Act at sections 53 sub 2 and 53 sub 3 do not circumscribe or narrow the tribunal's powers in the way suggested by Canada in this case. It was certainly open to the legislature to say, in cases seeking systemic remedies, there cannot be individual compensation. I could draft it myself. The legislature could have put something narrowing the authority of the tribunal, and they chose not to. And as a result, we say, at the very least, at the very basic level of this case, the tribunal did what it could do under its act and what it was statutorily allowed to do. And so just on that basis alone, just looking at the language of Section 53 in the context of the overall Canadian human rights scheme, the tribunal had jurisdiction to order individual compensation. Just on that basis. There are many other reasons, but just on that basis alone, we say that it could be ordered. Now, the provision of appropriate compensation to victims for their pain and suffering, and the compensation for having experienced willful and reckless discrimination are essential to the fulfillment of the Canadian Human Rights Act quasi-constitutional objectives. Forward-looking orders require respondents to cease their unlawful practices. Coupled with compensation for victims, they are given a recognition of the infringement of their dignity. As my colleague, Ms. Levesque says, this is the 1-2 punch of human rights remedies. Systemic, long-term reform remedies and financial compensation that recognizes the infringement of dignity. As the Federal Court of Appeal states in Jane Doe versus Canada, Once pain and suffering caused by a discriminatory practice is established, damages should flow. Now, there's nothing in the Act, as I said, that limits compensation in systemic cases. Canada's attempt to build its argument around this theme is highly suspect and is only being made at this late hour, in our view, to obfuscate the focus away from its responsibility to First Nations children that it has harmed. The CHRA, the Canadian Human Rights Act, grants the tribunal the authority to make systemic orders and award compensation to victims that have experienced both pain and suffering and willful and reckless discrimination. Now, Mr. Frater talked about the Supreme Court's decision in Moore. In Moore, the court there explained that discrimination cannot be understood in a binary way, this idea of systemic versus individual. What I really heard Mr. Frater talk about this morning was, you didn't pick a lane that you wanted to drive in. You picked the systemic lane, and so you're stuck with that, which I'm going to talk about later is not actually true. But in any event, that's not what the Supreme Court in Moore says. At paragraph 58, the court says in Moore, it is neither necessary nor conceptually helpful to divide discrimination in these two discrete categories. A practice is discriminatory whether it has an unjustifiably adverse impact on a single individual or systemically on several. The only difference is quantitative, that is, the number of people disadvantaged by the practice. And this is where Canada's argument ignores the experience of the child at the individual level. Yes, it runs big systems, it runs a giant bureaucracy, but its actions and conduct have real life implications for the individual children who needed those services who were denied based on their First Nation status. In some respects, what Moore tells us is that you can be a tree in a forest, but you can't be a forest without the trees. That is what Moore is all about, and that's what this case is about. The forest, which is this giant system of child welfare services, is made up of all the trees who represent the children. So Canada is wrong for citing Moore, for this idea that we are the flip side of their case. We are not the flip side of the Moore case. It is not binary in that way. We are an example of what exactly Justice Abella is talking about here, that you have taken individual victims and made your discrimination so widespread that we call it systemic. That's what we talk about when we talk about systemic discrimination. It's that the discrimination is so big and so wide that it touches on thousands and thousands of children across the country in this system of child welfare and in this system of social services. So it's not about only providing systemic remedies where there's a systemic case. It doesn't make any sense. Where complainants have proven both systemic discrimination and individual harms, as we have done here, both systemic and individual remedies ought to be awarded. So it's a peculiar argument. Canada seems to be saying, particularly in their factum, not so much this morning, that if Canada had confined its discrimination to a particular province or to a particular community, or discriminated against a smaller number of children, that it would be liable for human rights compensation. We don't think that makes any sense. Now, there is precedent for ordering both individual and systemic remedies together, and we cite those cases in our factum. So in Hughes, for example, the tribunal ordered both systemic remedies and compensation to the victim who was harmed by Elections Canada. That's 2010 CHRT 4. And also in Hogan in Ontario, the Ontario Human Rights Tribunal there ordered significant changes to Ontario's sex reassignment surgery policy, but also ordered the respondent to pay each victim of discrimination financial compensation. And so the cases that are cited by Canada on this point are not overly helpful, and certainly in their factum, the academic articles are not assistive. And you'll see that in our factum. I'm not going to take you to it now. I want to address some of Mr. Frater's comments this morning around this notion of jurisdiction and the statement of particulars and where we all fall on those things with respect to jurisdiction. So Canada says that there's a shifting in the evolution of the complaint, that, for example, as you rightly pointed out, the Caring Society statement of particulars focuses on a limited dollar amount and was seeking for the compensation to be paid into a trust. So I have 4 responses to this important point. So first of all, the context of the case must be kept in mind. Those statement of particulars were drafted in 2009. Many other children since 2009 have been removed from their homes or denied or delayed accessing social services. So the dollar amount, of course, was a best estimate at the time of what the magnitude of the discrimination was, but that was more than 10 years ago. Now, regarding the willful and reckless jurisdiction and the fact that it was not sought in the statement of particulars, as I noted at the beginning, many of the documents that indicate the knowledge level of Canada and the fact that it was frankly costing out its own discriminatory practice, many of those documents were not disclosed to the parties until 2013. And in fact, the tribunal finds that Canada knowingly kept them from the parties. And that is very problematic. Now, there's nothing in the statute or binding in law to suggest that the tribunal is required to select only the remedies proposed by the parties. In fact, the opposite is true. The tribunal's role is to uphold the principles of the Act and fashion remedies that are in the best interests of justice. So the tribunal was not restricted in any way from only choosing what the Caring Society requested or only choosing what the Assembly of First Nations requested. In fact, the tribunal in certain places in its own decisions said no to many of the requests made by the parties. For example, both Chiefs of Ontario and Anishinaabe-Aski Nation did ask for the categories of victims to be expanded in this case, and the tribunal simply said no. And that's because the tribunal has the discretion to order the remedies that best fit the case. Finally, I think it's important to note that Canada has always known the parties were seeking compensation. Certainly, to suggest otherwise, as the tribunal says in its decision, would be unfair. Even in 2014, when we raised compensation in our closing submissions, they only argued that compensation, that there wasn't enough evidence for compensation. And there, in fact, we included an excerpt from their factum at tab 46 of our compendium, where they talk about the fact that there's simply no evidence to support an award of financial compensation here. They don't talk about, well, you're really asking for systemic remedy, so you can't get individual compensation. That argument really did not bubble to the surface until 2019. So it's a bit disingenuous to say that that there was a procedural unfairness to them with respect to financial compensation. They knew about it, and they just simply chose not to act on that issue. I'm not going to talk much about the Brodsky and Hart article, but I do think I will just say to Your Honor for your bench brief that the Hart article is an important springboard. And I'm probably going to come to it a little bit tomorrow, but she talks about, Justice Hart talks about that in that article about rough justice. That rough justice is an important tool for human rights tribunals to ensure that they're properly redressing systemic claims. And that's part of what's happened here, right? It's important. When Mr. Frater said today, that this is a massive compensation order, he's not wrong. But it's only massive because of Canada's widespread discrimination. The nature of the discrimination, it's widespread because it discriminated against thousands and thousands of children. It's not the fault of a child from Wapakika or a child from Deer Lake or a child from Tagwatagamo or a child from Attawapiskat or a child from Norway House Cree Nation, that they are one of thousands of children who were harmed by Canada's discriminatory conduct. Each and every one of those children experienced Canada's discrimination on an individual level as individual children. To seek to avoid financial liability because it is systemic and so widespread tells us that Canada has learned very little from the lessons of residential school, the 60s scoop, and has not spent the requisite time reflecting on the stories and guidance provided by the Truth and Reconciliation Commission, and ultimately by the guidance put forward by the tribunal in the merits decision. There is no question that the tribunal had the jurisdiction to order individual compensation in this systemic case, examining the purpose of the Canadian Human Rights Act and what was at stake for individual victims. And ultimately, this is what the tribunal has accomplished. So on this point, Your Honor, we say the tribunal absolutely had the jurisdiction to do what it did. And it actually, in fulfilling its role under the Canadian Human Rights Act, fulfilled that jurisdiction in a responsible and reasonable way. So I can move to my third submission, but I'm just noting the time. Perhaps we could take a small break now. I've been talking pretty straight for an hour and 15 minutes. But I'm in your hands, Your Honor. I'm happy to keep going if that's what you would like to do.
I think probably a break would be useful for everybody. So it's almost 3:20 my time. So why don't we reconvene at 3:30? So just
very good, Your Honor. Thank you.
10 minutes.
Thank you, Your Honor. The court will be in recess until 3:30.
Recording stopped.
Welcome back, Council. Ready to proceed, Mr. Justice?
I'm ready. Ms. Clark, are you ready?
I'm ready, Your Honor.
Perfect. I will start the recording.
Thank you, Madam Registrar.
You're welcome.
Recording in progress.
Thank you, Your Honor. So just before I begin my third submission, I just wanted to clarify something that I've been saying throughout my submissions today. When I've been talking about Jordan's principle, I've been talking about social services. And I just want to make clear that when I'm talking about social services, I mean social services broadly and generally. What I really should be saying is public services. So we know from the tribunal's reasons that Jordan's principle covers health, education, and social services. So I just wanted to make that clarification just in case there was any confusion. When I say social services earlier today, I really am talking about the larger umbrella of public services, that children have been denied access to those public services generally in the areas of health, education, and social service. So I just wanted to make that clarification for your Honor's consideration.
Thank you.
So what I'd like to do between now and roughly 4 o'clock, depending on how far we get, is really spend some time this afternoon really looking at the reasons. And what I would say is that it's important to remember, as I said at the outset, when I was talking about Vavilov, that it's about the internally coherent nature of the reasons themselves, not applying a de novo standard or your own or Canada's own personal view of what the reasons should have said or should have done. The question that Vavilov asks is whether or not the tribunal has actually constructed its reasons in a way that you can understand. Is it logical? And are there any fatal or what I would consider to be fundamental flaws in the chain of reasoning? And we say here, first of all, that that's certainly not the case, that when you look at the compensation entitlement order, even on its own, in its own little box, you see that there is an internal consistency and logic in the reasons. But more importantly, when you look at those reasons in the context of this case, and as one of many, many decisions made by the tribunal over the years, it becomes even more reasonable, and the underpinnings of the decision itself become amplified. And so what I would urge the court to do here is when you're looking at the compensation entitlement order and its reasons, to also look at the other decisions. In fact, I would really urge the court to read them in one sitting. I mean, it's a lot of pages, it's a lot of things, but when you actually sit down with the merits decision and read all of the non-compliance reasons that come after it, and then you come to the compensation decision, you actually see the entire context and underpinnings for both the reasons and ultimately the outcome. We do agree with Canada that Vavilov says you've got to look at the reasons and the outcome, so we don't dispute that, and that's what the court should do through that reasonableness review. But it is important to understand the context of this case. There really has been no other case like this. And so it's true when Canada says there's no precedent. Well, that is because there has never been a case like this. And the tribunal, who has been seized of this since 2012, knows that. And so those are my opening comments about really when you're looking at the reasons, just to keep the context in mind. It's really important that be at the forefront. And so we know from Vavilov that the reasons as a place of first principle are entitled to deference. And really all we are doing through this hearing is making sure that both the reasons and the outcome are logical, consistent, and make sense. And it's important also to keep in mind that the tribunal sat through 70 days of evidence. They reviewed thousands of pages of evidence, and they are experts in human rights remedies. That is also to be kept at the forefront. So I'd like to examine the entitlement reasons and take you through a number of different areas that I wish to highlight that really demonstrate that when you look at it in the totality of the case, and even within the four corners of the decision itself, it demonstrates a clear reasonableness. And I first want to start directly with the specific considerations that the tribunal gives to Canada's arguments. That compensation should not be awarded. And in fact, some of the arguments that we heard earlier today are being repeated. So this is something that's quite important. Did the tribunal give consideration to Canada's arguments on this case? Yes, it did. And the first place to start with that issue is at paragraph 46. And so I'm using my friend Mr. Frater's compendium for this exercise. That would be volume 2 of Canada's compendium, tab 1. And that's where we find the entitlement decision. And so when we look at paragraphs 46 through 80, the tribunal painstakingly reviews Canada's arguments and contextualizes them within the context of the case and gives them, I would say, a real space to understand what Canada is actually arguing and why it's doing what it does. And that's important because it's not as though the tribunal simply ignored Canada altogether. It simply just did not agree with its interpretation of what its role was. So I would really urge the court to look at paragraphs 46 through 80 together in their totality, because they demonstrate that the tribunal gave due consideration to those arguments and just simply did not agree with them. The second paragraph, or the second section I would have you look at with respect to Canada's arguments is paragraph 182. And so here we see the consideration of Canada's arguments around the class action, right? And that's important. It's what the tribunal says here with respect to this argument is that, and this is what I was alluding to earlier, other pain and suffering caused by other actors could potentially be sought in other forums. The panel's role is to quantify as best as possible the appropriate remedy to compensate victims/survivors as part of these proceedings with the evidence available. So there you see a clear indication from the tribunal that it really understands its role. It acknowledges, as I said, that there is other pain and suffering associated with this case and the victims in this case, but that really the panel's role is not to go outside the four corners of the act. They really have to stay there and do what they can do respectively. And so we say that they do that. Now, Mr. Frater earlier said they were not saying at the hearing on the compensation that all children should come to testify. And we agree with that. They were not saying that every child should come and testify. What Canada said this morning was no child testified, and therefore there can be no findings of harm. At least that's how I understood the argument. The panel doesn't say that Canada said they had to bring every child. What the panel says at paragraph 187 is that the panel acknowledges the suffering in the unchallenged decision. It did not have individual children who testified to the adverse impacts that they have experienced. Nonetheless, the panel found that they did suffer those adverse impacts and found systemic racial discrimination based on sufficient evidence before it. So this is a real understanding on the part of the tribunal and this panel in particular, that they didn't need that individual evidence. And as you alerted to earlier this morning, Section 50 sub 3 really gives the tribunal the ability to accept hearsay evidence and to accept reports and to accept information that may not be admissible in a court. And that's what they did here. And so they talk about that in the decision, and they acknowledge that children did not come and testify about their harm, but they didn't need to. The other paragraph on this point that I wanted to take you to, which I think is important, and I will circle back to this tomorrow when I talk about class actions and the causation and proportionality and those kinds of arguments that were raised earlier, is that it's important to know as a practical matter when we're talking about the rights of victims that there is an opt-out possibility under this tribunal order, and that's at paragraph 201. So victims are not going to be, required to collect their compensation through the tribunal's orders. If there are other legal avenues open to those victims, they will be free to opt out of this process. And so when Canada talks about, particularly in its factum, concerns around the rights of victims and their ability to control the proceeding and things like that, it's important to know as a practical matter that the tribunal considered those arguments on the part of Canada and made it clear that quite reasonably that people can opt out of this process. So that would be my first consideration. The second point with respect to the reasons that I want to draw your attention to is that the tribunal's decision is really grounded in its previous findings in this case. And it makes that point in many places. I'll just take you to a few, but that's really important because those findings are unchallenged. And so if those findings are unchallenged, which they are, it's very reasonable that individual compensation was awarded in this case. So I'll start by taking the court's attention to paragraph 15 of the decision. And what the panel says here is starting with the second sentence, the panel has made numerous findings since the hearing on the merits contained in 10 rulings. Those findings were made after a thorough review of thousands of pages of evidence, including testimony transcripts and reports. Those findings stand and form the basis of this ruling. And that's why I was urging you earlier, Your Honor, to really see this as part of the entire overall complaint process. When the tribunal decided to structure the remedies in this staged approach, no one challenged the tribunal's ability to do that. And so what it's saying to all of us here is this is only one piece of the puzzle. You need to look at the other puzzle pieces in order to have a full picture of what we are trying to accomplish for these children and these families. And the court goes on to say there's compelling evidence exists in the record to permit findings of pain and suffering experienced by a specific vulnerable group, namely First Nations children and their families. While the panel encourages everyone to read the 10 rulings again to better understand the reasons and context for the present orders, some ruling extracts are selected and reproduced in the pain and suffering, Jordan's principle, and special compensation sections below for ease of reference in elaborating the panel's reasons. And so that's really important as well. What the tribunal is signaling is not, as Canada suggested earlier today, that the tribunal sort of blindly picked things out of nowhere, that these are part of a greater context, but because of the amount of information, the amount of evidence about the discrimination in this case and its impacts, they did their best to pick some things from the record. But again, it's just an indication that there's so much to consider and that they truly did consider so many things when they came to their decision. Now, I'd like to take the court to paragraph 155, which Mr. Frater took you to earlier today as an indication of the pain and suffering in the past rulings, which he says does not, when you look at it, sort of measure up to the level of harm that they would have expected for a pain and suffering award. And I should just pause here to say that while Canada has said numerous times today, the evidence is not there, the evidence is not there, the evidence is not there, they've never once indicated what kind of evidence would have met the threshold that they are thinking about. I think that's an important consideration. I just think that it's, and I'm going to talk about this later tomorrow, but I just want to put that out there for thought because it's really unfair to say, on the one hand, we know that we caused harm, but you didn't bring anybody who experienced the harm to actually say, I was harmed, and then say, well, we're not going to give you compensation because even though we knew about it, you didn't bring anybody in the room to say it out loud. That does a real disservice to what we are trying to do in the promotion and protection of children's rights in this country. And I think it's a real disservice to children across the country to say, because you didn't come in the room and spill your guts or share your trauma, you are not worthy of a compensation award. In any event, notwithstanding that no child did that, in our view, what paragraph 155 does in a really important way is really set out the foundation for that pain and suffering and for that trauma. And when you read through this section in paragraph 155, you can see the logic and the rationality of what the tribunal is doing here. It is really unpacking for the reader some of the highlights of what it found in the evidence and through reviewing the record. That children have been impacted by the funding formula, by residential schools, by the mass removal of children. We know intuitively that these things cause harm. The example I always like to talk about is in a child protection case. If you have a parent that has not fed their child, you don't need an expert, a nutritionist expert, to come and testify as to the harms of not feeding a child. We all intuitively know what will happen to a child who is not fed food. And very similarly, we know what happens to a child when they are removed from their home. We know that it causes harm. And that's all that was really needed in this case. And that's really what the tribunal does in paragraph 155, is shines a light on some of the really important findings from the evidence. Now, paragraph 158 is also important because this is part of the direct evidence that's talked about from the perspective of the child welfare system. Now, Mr. Dubois is not a child, but he is the executive director of Touchwood, which is a child protection agency. And what he says in his evidence is that you had to break up a family under Directive 20-1 before you could provide the service. It's only when you took a child into care that you could start to rebuild the family. So that in and of itself is exactly the harm that I was speaking about earlier today and that the tribunal sees in all of its evidence. It's this underpinning of denying children service because of their identity and then having to bring them into care in order to provide the service. And we as a collective intuitively know that that causes harm to a child. So this, even referencing this one small sentence in the record, demonstrates the reasonableness of the tribunal's reasons and outcome, because it clearly shows that they were directly in tune with that intersection of the discrimination and the harm, that failure to provide service with the removal. That's the intersection that the panel is driving at here. I also will lastly take you to, there's many places to take you, but I did want to take you to paragraph 165, because again, the tribunal spends time looking at the inadequacy of the funding as well as some of the important gaps in services under Jordan's principle. So we see here that the tribunal is really contextualizing its findings and thinking about what is actually happening to the child, right? It's important that we understand that, for example, for Jordan's principle, which is on page 49, where the evidence really talks about the gaps in services and the resulting suffering of First Nations children. It's not simply that you just didn't get something when another Canadian child may not have gotten it, but you're getting it under Jordan's principle. I mean, Canada suggested this morning that that's unreasonable, and we're going to talk about that more tomorrow. But that's not what the evidence was about in this case for Jordan's principle. The evidence was about, again, that intersection of the discrimination and the suffering that resulted from the infringement of the dignity. So those are just some of the highlights where it really demonstrates that the tribunal had a very reasonable and rational chain of consideration of the evidence given the context of the complaint. So third, the tribunal made really important findings in the compensation entitlement decision about pain and suffering that are logical and reasonable in the context of the case, particularly when you examine them from the perspective of the child. And that is what the tribunal has always tried to do in this case. That's why the opening paragraph of the merits decision is about the children. It's not about government systems or bureaucracy or funding models. It's about the kids. And that's what the tribunal has always done. So I'm just going to highlight, I see the time is just marching along. I'm going to just take you to a couple of the paragraphs just to make sure you have them in your bench brief for when you review. So starting with paragraph 128. This is where we see what I've been driving at all day, which is this intersection of the infringement with the harm. And the court says here, when someone endures pain and suffering, there is no amount of money that can remove that pain and suffering from the complainant. Moral pain related to discrimination varies from one individual to another. Psychological scars often take a long time to heal and can affect a person's self-worth. From the point of view of the person that suffered discrimination, large amounts of money should be granted to reflect what they lived through and to provide justice. That being said, when evidence establishes pain and suffering, an attempt to compensate it must be made. However, $20,000 is the maximum amount that the tribunal can award under Section 53 sub 2 sub E. And the tribunal only awards the maximum amount in the most egregious of circumstances. So again, the tribunal is saying to victims in a very respectful and honest way, we know that you have additional pain and suffering. Some of you have maybe psychological scars. Some of you have other forms of pain and suffering. But we have a limit. Our jurisdiction contains us to Section 52 sub 2 sub E, and we can only give you that amount. And that's a real reflection, again, of the reasonableness of really the tribunal understanding its position, but also, frankly, being respectful to the children. At paragraph 147, this is what I was speaking about earlier. This really, to me, again, demonstrates the reasonableness of what the tribunal is trying to do. At paragraph 147, the tribunal says, the children who were unnecessarily removed from their homes will not be vindicated by a system reform, nor will their parents. This is exactly what I was talking about with respect to the 1-2 punch of human rights remedies. Those systemic remedies, those long-term reform and the hopeful long-term implementation of Jordan's principle will not do anything to vindicate the victims in this case. And so the tribunal recognizes that these kids will not benefit from reform and builds into its own analysis a reason why these children should be compensated. And in our view, that's entirely reasonable. I want to take you now to paragraph 161. Because this is a finding in the decision that appears to be unchallenged by Canada. And based on this finding, we'll see that the rest of the decision hangs together. Paragraph 161 says, the panel finds that unnecessarily removing a child from its family and community is a serious harm causing great suffering to that child, the family, and the community. If that's acknowledged by Canada, then it's quite reasonable that those victims receive individual compensation, given that they are capped and that they are contained within the human rights framework. And to support that finding, they say at paragraph 169 that the panel finds there is absolutely no doubt that the removal of children from their families and communities is traumatic and causes great pain and suffering. And then they review a lot of the information and evidence that they received in the case, and in fact, look at RCAP as an important consideration in that determination. I would just say also that the evidence of Marie Wilson, which is referenced at paragraph 172, was unchallenged by Canada in the compensation hearing. And that Ms. Wilson's evidence came in at that compensation point in the case, was not part of the main case in when it was argued in 2014. But she talks about, Ms. Wilson talks about the moment of removal being the greatest trauma for children who were sent to residential school. That removal itself is the trauma, it is the harm, and it is the pain and suffering. And we say that based on Ms. Wilson's evidence, that it's quite reasonable to think if you were removed to go to residential school or removed to go to foster care, it's the removal itself that causes the harm. Being taken from your family causes harm, and that's a reasonable chain of analysis because it's the removal that causes the pain, not where you go after. Two quick points on the Jordan's principle. At paragraph 222 and paragraph 224, again, the tribunal sets up its determination on compensation for Jordan's principle based on the evidence and the findings that have been unchallenged in this case about the gaps in services to children, about the impact of those gaps, and how it was always meant to apply to all First Nations children. That those things are really important. Talks about Wapakika and the children there who were denied mental health services because it was an awkward time for Canada in its federal funding cycle. And that children died as a result of Canada's inaction for public services. That is a very important consideration. It doesn't mean that every child has to die or has to come close to death in order to be legitimized for compensation. It demonstrates how serious the nature of Jordan's principle is and how important ensuring access to public service is essential to the health and well-being of First Nations children. Because it's not just about the crisis at the end of the tunnel, it's about all of the things in between that are essential to ensuring the well-being of First Nations children. So it's important that that is considered. And the other important piece about Jordan's principle that the tribunal highlights here in this very long recitation of many of its findings of fact is the acknowledgement on the part of Canada that Jordan's principle is not a program. It's considered a legal obligation. And so on the CFS side, we have a Child and Family Services program that, is subject to the Canadian Human Rights Act and has important considerations. But Jordan's principle is a legal obligation on the government of Canada. And that is important to understanding the direct nature of the discrimination under Jordan's principle. As I said earlier, there are complicated bureaucratic considerations on the Child and Family Services side because there are agencies and others who do the important social work. But with Jordan's principle, there's a direct relationship between the child and the government. And that direct relationship is informed by a legal obligation. And so that pain and suffering, that willful and reckless conduct, the nature of the harm and the infringement of the dignity is all the more amplified in Jordan's principle because it's more direct. Finally, I would just say in my closing minute that it's really important to look at the tribunal's reasons through the legal framework that it brings to the table. The tribunal grounds its reasons throughout in the case law. It really does examine the legal principles of remedy. It examines the legal principles of pain and suffering, and it examines the legal principles of willful and reckless. I would just say with respect to some of the cases that Mr. Frater spoke about earlier, those are not necessarily binding on the tribunal. That in fact, what the Canadian Human Rights Act calls for is a tailored remedy to the circumstances of the case, to the context of the complaint, and ultimately, to the overall framework of how the case unfolded. And that's what the tribunal does in referencing many of the cases that we cite in our factum. Johnstone, Moore, the JG case. These cases really contextualize the reasonableness of the tribunal's submissions or tribunal's reasons. And I didn't hear Canada say today that simply the tribunal did not consider binding precedent on it. That's not the case. Every time it takes a step in a direction away from what another case has done, it explains those reasons. It explains why it has done that. And then it situates that decision in the context of this case. And that's what really shows the internal consistency, the internally consistent nature of the tribunal's reasons. So it's important that that's recognized. The last thing I'll say on the tribunal's reasons is what Mr. Frater talked to you earlier today about sort of the difference between Natrium Network and Lafreniere and some of the other cases about, most egregious, more serious. We would say that that's a red herring. It's really a distinction without a difference for the purposes of this case. Whether or not this court says the standard is more serious or most egregious, those are both met in this case. And the tribunal does a reasonable job of setting out the framework that supports most or more. In our submission, the evidence supports the most egregious. We don't think that there's any question about it. When you examine the award made to Dr. Blackstock, and I keep coming back to that because it situates the reasonableness of the decision. Dr. Blackstock was awarded $20,000, 10 for pain and suffering and 10 for willful and reckless, for one incident in a professional capacity. These children were removed from their home or denied or delayed in receiving basic public services, and they got 40. That's more than reasonable. And certainly in the context of this case is in keeping with the principles that of harm and pain and suffering and the context and the indignity suffered here by the children who were touched by the discriminatory conduct of Canada. So I think I'm in your hands. I would leave it there. I will come to a number of issues tomorrow, but if the court is satisfied, I won't move on to a totally new subject, given that it's now 4 o'clock.
Thank you, Ms. Clark. I think we could leave it at that for today. So thank you for your submissions. I note that the total amount the parties had discussed was 3 hours. So I think you've got an hour left thereabouts for tomorrow.
Thereabouts. Maybe Mr. Frater wants to share some of his time with me. Probably not. Yes, I will. And taking the break now, to be honest, Your Honor, will allow me to make sure I'm really contained within my time frame. So I will be doing that.
So that'll leave us, I think, if just putting the AFN on notice, I think if you're prepared to go through your submissions tomorrow, you're allotted 3 hours. I think part of your time was allotted to day 3. Would you be prepared? Are you able to finish your submissions tomorrow with the time allotted of 3 hours? Either Mr. Nagabo or Mr. Wutke?
Are we on? Yeah. I believe we can complete our submissions tomorrow, Justice Fable. Assuming, I'm not sure how much longer Ms. Clark will take. If she's done by the morning, we'll have some time in the morning, I'm assuming, and then probably a bit of time in the afternoon. If we have an hour in the morning and 2 hours in the afternoon or something in that nature, we should be able to finish.
Okay. And I'm not holding you to that, of course. If people need breaks, we'll come to that, just giving a bit of notice that if we do have some time to do that, to finish your submissions, it'll be there for you to take it if you wish. So, okay. Well, thank you, Mr. Nagabo, for that. And That'll conclude today's proceedings. We'll see you tomorrow at 9:30 a.m. Have a good evening.
Thank you, everyone. The court is now adjourned for tomorrow, June 15 at 9:30.
Thank you. Thank you, Your Honor.
Recording stopped.